To be eligible for Social Security disability benefits, you have to have employment in 20 of the last 40 quarters or 5 of the last 10 years. If you have that, then you're insured for Social Security disability benefits. The amount of your benefit will depend on how much you paid into the system over the years of employment. If you're not certain whether you're insured or uninsured, you can get a copy of your earnings record from the Social Security Administration, and that will show you all of the quarters that you have reported income in and the amount of that income for all of the years that you've been employed. To be eligible for Social Security disability benefits, you have to demonstrate that you have a serious medical condition. That medical condition can be a physical impairment or it could be a mental impairment. There's no restriction on what sort of injury or illness can qualify for Social Security. What is required is that the injury or illness disables you from work for at least 5 months and is expected to disable you from work for at least a year. The test is whether you can engage in substantial gainful activity. You don't exactly have to be totally disabled, but you have to be unable to do any significant work or be unable to do work that will generate any significant income. Social Security takes into account more than just your medical impairment or your medical condition. It also looks at your age, your education, your work experience, and your skills. Someone who's older and has less education is more likely to be approved than someone who's younger and better educated. One of the common mistakes people make when they're applying for Social Security disability is they think that having more different doctors talking about their condition will be an advantage because it provides more evidence in the case. In fact, Social Security has a rule called the treating physician rule. And what that means is if a doctor has seen you on more occasions or over a longer period of time, then that doctor's opinion carries more weight and has more credibility with the Social Security Administration and will be more persuasive in proving your case. So we recommend that people pick a doctor and stay with that doctor throughout the entire process. If you need to see other specialists along the way, that's fine, but it's important to have a treating physician to help you win your case in the end. The initial application involves you filling out a form with many pages talking about the nature of your injury, your disability, the doctors you've seen, and the things you can and can't do. After Social Security gets your initial application, it will request medical reports from all of the doctors who you identify. It often takes the administration 4, 5, 6 months or more to make a decision on an initial application, and most applications are denied on the initial application. Too often people are discouraged when they get the denial from the initial application and they think that that's the end of their claim. That's not true. After an initial application is denied, you have the right to request a hearing in front of an administrative law judge. Most of the cases that we handle at hearings before administrative law judges are decided in favor of the disabled person, even after the initial application was denied by the administration. Unfortunately, it takes a long time after the denial of the initial application to get to a hearing in front of a judge. The most important thing someone can do while they're waiting is to continue to keep track of all of the doctors they've seen, to continue to keep a list of all of the medications you take, and to let your lawyer know if there are any new doctors or new medications or new disabilities that have occurred, so that when the case comes to a hearing, all of the evidence will be ready and available to give to the judge to try to get the best result.